Hey, I'm Nancy Cavey. I'm a National ERISA and IDI disability attorney, and I want to welcome you to Winning Isn't Easy. Before we get started, I've got to give you a legal disclaimer. This podcast is not legal advice. The Florida Bar Association says I have to say that, but now that I've said that, nothing will ever prevent me from giving you an easy-to-understand overview of the disability insurance world, the games that disability carriers play, and what you need to know to get the benefits you deserve. So, off we go. Now, when you apply for long-term disability benefits, you have the burden to prove that you're disabled, as those terms are defined in your policy or plan. Now, in most disability policies or plans, the definition of disability will change over the life of the policy or the plan. Initially, you have the burden to prove that you're unable to perform the material and substantial duties of your occupation. Now, there are two material terms that I just mentioned. The first is an inability to perform the material and substantial duties, and occupation. Now, guess what? Unfortunately, there is no uniform definition of those two terms. And you actually have to go to the disability insurance policy or plan and see how those terms are defined. Because again, you've got to prove that you meet that standard of disability. Generally, and historically, after 2 years of the payment of your own occupation benefits, the standard of disability will change from an inability to do your own occupation to an inability to do any occupation. And again, you need to understand what that term means. But as a practical matter, you ultimately have to prove that you can't even do what's called a sedentary job. Now, as part of the analysis of your capacities, your physical capacities, the disability carrier or plan may say, you have to undergo a functional capacity evaluation. And you obviously need to read your policy or plan, because sometimes they will say, we want you to have one, but the policy or plan doesn't require you to have one. But let's assume, for the sake of this podcast, that your policy or plan requires you to undergo a functional capacity evaluation. If you don't go, that in and of itself can be a reason for the denial of a claim. Now, the FCE is just one tool in the disability carrier plan's denial toolbox. I think that if that happens, in other words, they say, we want you to have an FCE, that's time for you to hire an attorney, because they're looking for a reason to deny or terminate your benefits. Now, I also want you to understand that as a policyholder or plan beneficiary's attorney, I turn that around and I use FCEs to our advantage to overcome a claim denial or termination. You can see the issue of a functional capacity evaluation can be really crucial to you getting or keeping your benefits. So I'm going to be talking about 4 things today. First, I'm going to talk about the nuts and bolts of a functional capacity evaluation. Number 2, how you can use a functional capacity evaluation to support your claim and overcome a wrongful denial or termination. Then I'm going to talk about the 7 mistakes that you can make during an FCE that's been ordered by your long-term disability carrier plan. And I'm going to talk about the 7 ways that the ERISA disability carrier plan are going to use the results of a compulsory functional capacity evaluation to terminate your benefits, and what you can do to protect yourself. Let's take a break before we get started. Welcome back to Winning Isn't Easy. Let's talk about the nuts and bolts of a functional capacity evaluation. Now, the purpose of a functional capacity evaluation is to objectively measure and prove your physical work restrictions and limitations so that the carrier plan can determine whether you're capable of doing heavy work, medium work, light work, or sedentary work. Now, those terms, by the way, are defined under the terms of the Dictionary of Occupational Titles and are commonly used by disability carriers or plans to determine not only the level of your past work, but the level of any other work they think you might be capable of performing based on the any occupation standard. Now, once the disability carrier determines what they think your level of physical functioning is, the question then becomes, from a vocational standpoint, can you do your own occupation if you're at the own occupation stage, or can you do any other occupation from a vocational standpoint? And courts have considered, by the way, the functional capacity evaluation to be a gold standard test for objectively measuring and proving restrictions and limitations, notwithstanding what your doctor or their doctors have to say. So, who performs a functional capacity evaluation? A functional capacity evaluation is typically performed by a licensed healthcare professional, such as a physical therapist, occupational therapist, or a physician. However, it's not uncommon for physical therapy assistants to perform the testing at the doctor or physical therapist's request. And they aren't present, but they will sign off on the assistant's findings. That's one of the tricks that disability carriers or plans will use to deny or terminate benefits. One of the first things we do when we see that type of game going on is we look to see how many signatures there are on the functional capacity evaluation and who was present and who is not present. What happens during a functional capacity evaluation? Well, typically the FCE provider will be given your medical records in advance. They'll see what your work history is, and they'll have a description of your occupational duties. Most likely at the beginning of the assessment, the physical therapist, the occupational therapist, the physical therapy assistant, or the doctor will conduct an interview. They're going to ask questions about your medical background, your current diagnosis, your symptoms, your treatment, your response to the treatment, whether you've taken any medication before the FCE. They may also ask you to take some psychological testing to determine your pain thresholds and whether they are out of proportion to what's commonly accepted or whether you're over-reporting your symptoms. Now, at my law firm, we request any paperwork be supplied to us in advance and be advised of any testing that's going to be done, particularly of a psychological nature. We're going to obviously prepare you for what's going to happen at the functional capacity evaluation, help fill out the forms, and certainly we will object to any psychological testing that they want to have you undergo as part of this functional capacity evaluation. Now, you're going to be asked to perform a range of physical activities and tasks, such as lifting, carrying, pushing, pulling, bending, stooping, twisting, turning, and the manipulation of objects. Generally, you're going to be asked to wear a heart monitor, which is going to be used to determine if you're giving full effort or not. If the heart monitor shows you're not giving full effort or you refuse the testing, the disability carrier may simply deny your claim on the basis that you haven't given full effort and you haven't cooperated with the testing as required by the terms of your policy or plan. The functional capacity evaluator is also going to be watching you. They'll observe your posture, the mechanics of your body movements, and any difficulties you may have as you engage in these repetitive motions. They're also going to note how your symptoms change, and the heart rate monitor readings should obviously increase as your pain level increases. When your heart rate increases because of increasing pain, the FCE provider will consider that to be legitimate evidence of pain because heart rate can't be faked. Now, you need to understand that there are several different types of functional capacity evaluation tests. In my view, they have to be scientifically valid and reliable to be admitted into evidence in any court proceeding. And there have been times when I've actually challenged an FCE as not being scientifically valid or reliable. The evaluation is also going to document your pain and fatigue levels, and they'll have symptom validity testing to ensure that you're not only giving maximum effort, but that the results are accurate. Don't be surprised if the disability carrier or plan questions the results of an FCE on the basis that you haven't given full effort, that any positive testing indicates that you would be unable to perform your own occupation, or the conclusions of the FCE if it doesn't comport with their goals. So they will actually try to take apart their own FCE if they don't like the results. Also, don't be surprised if there's surveillance on you the day before you go to the functional capacity evaluation, the FCE day, and the day after. Why? Well, because they're going to try to catch you doing something you said you couldn't do during the FCE the day before or the day after. Now, I want you to be aware that many times people are going to be in pain after the FCE, and they will limit their activities. So if you're reporting, hey, look, I'm in pain, I'm having difficulties as a result of this FCE, and the day after the FCE, they have surveillance of you doing something you said you couldn't because of that increased pain, that's going to be a problem for you and could result in a claim denial or termination. So you need to understand that surveillance can be part of their denial game in conjunction with the FCE. How long does a functional capacity evaluation last? Well, it depends. How long the FCE lasts depends on the complexity of your medical condition and the nature of the testing being performed. Commonly, an FCE will last about 4 to 5 hours, half a day. In the case of chronic fatigue, it could be a 2-day FCE. Now, I know that an FCE for 2 days can be really taxing, but it can help measure your sustained functionality over an extended period of time. The impact fatigue has, both physically and cognitively, and it can demonstrate why you might not be able to meet the demands of a regular or full-time schedule, meeting the pace and production requirements. So there are times when a 2-day FCE is appropriate. Who pays for that functional capacity evaluation? Well, if the disability carrier plan is requesting that you undergo the FCE, they're going to be paying for the FCE. You can be assured that they're going to be using a captive vendor who is going to give them what they want because they want to have repeat business. I mean, you understand that. So you can expect that there's going to be bias because of who's paying for it. Now, on the other hand, if we're requesting a functional capacity evaluation, your health insurance company may cover it, not all of them do, and otherwise the cost, of course, will be borne by you, or if you're represented, potentially your attorney. And the cost is going to depend on the length of the FCE, the complexity of the FCE, the number of medical records they have to review, and the nature of the testing that you or your lawyer wants performed. There are times when I want the FCE provider to basically simulate what my client's own occupation duties were as part of the FCE to prove that they can't do that. Got it? Now that we've established the basics of the FCE, let's take a break. And in the next segment, I'm going to talk about how you can use an FCE to support your claim and overcome a wrongful claim denial or termination. Let's take a break.
Robbed of your peace of mind by your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claims process. Request your free copy of the book at caveylaw.com today.